Good afternoon, Chairman and members of the committee. My name is David Goldman, and I am the Policy Counsel for the American Civil Liberties Union of Georgia. Today, I'd like to share the ACLU of Georgia's grave concerns about HB 1274 as currently drafted. Our primary concern with HB 1274 is that this bill would prohibit constitutionally protected speech and risk criminalizing the expression of criticism of the government of Israel. The International Holocaust Remembrance Alliance's definition adopted by this bill is overly broad. While the definition goes to some lengths to exclude criticism of Israel, the line between criticism of Israel and discriminatory animus remains too blurred to function as a law that ultimately punishes people for their speech. One such note in the IHRA's definition is that criticism of Israel, similar to that level against any other country, cannot be regarded as anti-Semitic. This language is unclear and unenforceable. The state of Georgia is not a ministry of information that decides whether certain criticism of Israel is similar to that level against any other country. For example, as a Jewish American who is frequently critical of recent Israeli administrations, I wonder whether my speech could be construed to run afoul of these restrictions. Or more likely, would a non-Jewish person making the exact same criticisms as me be considered anti-Semitic while I am not? That is the determination we are leaving to the state of Georgia to make, and that is problematic. This definition remains useful as a moral or sociological definition, but not as a legal one. Even the Office of the United Nations High Commissioner for Human Rights, which has adopted the IHRA's language as a working definition, has clearly stated that this definition is a non-legally binding definition intended to guide and educate. It is not a means to squelch debate or free speech, and those who misuse it this way should be opposed. The ACLU of Georgia also believes that this legislation is unnecessary. Importantly, Jewish Georgians are already protected by the Georgia Code and the Civil Rights Act of 1964, under which numerous courts have held that Jews, whether actively religious or not, are protected from discrimination under the race and national origin language. Ultimately, HB 1274 would have a chilling effect on constitutionally protected free speech. This committee should not pass this legislation as drafted. And at the very least, this committee must reconsider incorporating the IHRA's definition of anti-Semitism in a Georgia law. Thank you.
Mr. Goldman, you have a question. Representative Walensky.
Hey, Mr. Goldman. Quick question. I guess you're speaking on behalf of the ACLU today, but was there severe concerns about how the ACLU, how the hate crimes bill would be used by prosecutors throughout Georgia? It's just concerning to me that we have the hate crimes bill adopted, which could be used in any way. And it looks like here we're trying to define anti-Semitism for the clear reasons I said before. But now there's concerns on how it would be used when the adoption of the hate crimes bill was adopted without those concerns.
Yeah, I am not aware of a particular instance where Jewish Georgians have not been covered under a certain incidents. We don't want there to be a gap or a loophole, and if this committee is able to identify that, we are happy to work with the bill drafters on the language. But yes.
All right, Mr. Goldman, there's a question from Representative Leverett.
Good afternoon, Mr. Goldman. Thank you for your testimony. I wondered, is the ACLU aware of a working definition it would feel would be sufficient for legal purposes?
As regards to language that would be acceptable to this bill, we're happy to take that offline and chat with the sponsors.
One other question, Mr. Chairman, if I may.
Yes, sir.
As I interpret this definition, there is about a 3-line broad definition of anti-Semitism, and then there are some contemporary examples, which actually, to me, serve as additional, more definite definitions of anti-Semitic acts. I wondered again, and maybe this is a discussion we can have offline, and I'd be interested in hearing the other witnesses' view of this. Are there a lot of the bullet points in that definition have nothing to do with Israel as a state? They have to do with singling out a Jewish person for some kind of persecution or violence simply because they're Jewish. or because they are associated with Israel as a state. And the comment would be based on some perception that there is this, association by virtue of their ethnicity or their religion with Israeli policy. And so I guess what I would like to pose is, are there certain provisions in that definition that could be stricken to resolve the concerns the ACLU has, at least, satisfactorily, while retaining some of the other provisions that seem to me to be completely non-objectionable from any perspective?
That is definitely a discussion to be had. I think there are, the two parts of it. There's the definition itself, which is very vague, and especially a certain perception of Jews. And then there are parts that we have concerns with in the incorporated examples. I would agree that some of those examples themselves aren't necessarily controversial, while others are. But I think this goes back to the larger point that this is a working definition. And in this bill and through comments during this hearing, it was mentioned that so many different entities have adopted this. Well, not all those entities have adopted it as law being incorporated into code, but rather as an illustrative guide. And I think that is something we want to put out there, that yes, this can be educational, this can be helpful, but we think being incorporated into Georgia law is very problematic, especially when there are criminal penalties and prohibitions at place that can affect people just expressing their constitutionally protected free speech.
So I want to follow.
Yes,
so I understand your response to that question, as lengthy as I admit it was. We know you do not feel like there are provisions of this, the examples in the definition that could be isolated within a definition that would stand constitutional and due process muster.
Well, that's something we should chat about. There are definitely problematic aspects of these examples here.
I understand, and I'm suggesting there's some things that could be stricken, I think, to address the concerns that have been addressed today while still preserving the essence of the bill. I don't know if the sponsor would want to do that, or if it will be necessary to do that. I'm just trying to have a conversation to see what
we will
the specific sort of texture of your objection.
Yes, well, we are 100% open to having that conversation about specific examples. If it would make the bill more palatable, we can go ahead and talk about that.
Thank you so much. Thank you.
All right, no further questions for you, Mr. Goldman. Thank you.